The long-awaited West Kingston Commission of Inquiry commenced Monday, December 1, 2014, and is shaping up to be as captivating as that of Manatt, Phelps and Phillips back in 2010. There are several issues which have come out from this inquiry, and I want to zero in on one: the issue of language. There seems to be a concern raised by society groups re the communication interactions between attorneys and witnesses. The points posited are fundamentally that the residents who have come forward as witnesses do not speak or understand the English language of the attorneys. It has even been suggested that there needs to be an interpreter present to improve communication. An interpreter for communication between a Jamaican and another Jamaican? Ladies and gentlemen, I find this to be an added disrespect to the people of West Kingston. Interpreter what? Not only do persons from Tivoli and West Kingston overall have to deal with the trauma they experienced in 2010, but would now have this psychological issue of class divide thrown in their faces if an interpreter were to be there. Interpreter what? Merely much ado about nothing and very condescending. What really is the problem then? And is there a communication issue? The answer is a simple yes to the latter. No, the witnesses do not evidence sophistry in their language and communication, but neither are they fools. So therefore, if my learned friends, the attorneys, that is, were to be more consistent with clear and simple language in their discourse, then there is likely to be a smoother flow. Further, the expected intelligence of these attorneys should warrant greater adaptation to their environment. This does not mean gravitating to speak patois when relating to the witnesses, because doing so may have the effect of unsettling same witnesses even further. How so? By virtue of being on different sides, the witnesses would have already not be trusting of the attorneys defending the state institutions such as the JCF and JDF. And given it is not the norm in expectation for attorneys to speak patois in the execution of their duties in the courtroom or an inquiry-like setting as this, could the witnesses further see this as a reason to be more apprehensive? Again, if attorneys resort to an approach of relating in patois to the witnesses, same could be construed as being quite condescending by others looking on. What is it? Tivoli people and West Kingston residents overall are not good enough to be addressed in English? Ladies and gentlemen, I declare this is not an issue of the ability or inability to speak English, but more one which needs amicable commonsensical approach. If the attorneys seek to express in a sophisticated, loquacious manner, this will only add to discombobulating the witnesses and justice will not be served. Come on. It cannot be easy for these West Kingston residents testifying. Again, they have to relive all the negatives that occurred in 2010, which includes personal injury, death or injury of family member, and the loss of property. All this they have to do in front of a camera televising their lives to the world. So therefore, the commissioners have a responsibility to have attorneys express in a simple, clear, and precise manner which does not necessitate attorneys taking a condescending position to speak patois. That's my take. What say you?